Hi, Jeremy Peterson here with Vesta Property Management in Ogden, Utah. And today I want to talk a little bit about a recent experience we had with the 2nd District Court in Utah and the Rapid Rehousing Program for a tenant that we had a wild experience with. And hopefully this provokes some conversation about policy, what's working, what's not working, and kind of cause us to think about what we're doing with affordable housing. And so the story starts out with a triplex here in Ogden, a little tiny one, a 1,200 square foot building that was cut up into 3 units back in the 1920s. So these tiny little 400 square foot units, we took over management in January, had to repair a vacant unit. And we knew just from the configuration and the amenities there that it was going to be a tough one to fill, and we were likely going to be working with a scratch and dent credit situation. And so we put the advertising out there when we got the unit ready, and we were contacted by a local charitable institution that was working with housing and urban development with a rapid rehousing program. And they approached us and said, hey, we got this person that we're sponsoring, and he's coming out of incarceration, he's on parole, and he needs a place to live. You know, what have you got? And we might like this little unit here. So we had them check it out. They liked the unit, and we agreed to work with them on this individual. And we'll not to use real names, we'll call this individual Cletus. So Cletus moves into the property, and immediately, like within days, we are having issues at the property. Cletus purchased a van that didn't work and then dropped it off in the driveway, and then moved people into the van, was borrowing electrical from another unit through the cellar of the house, and was providing electricity to the van. Junk started to pile up on the property. We had strangers living in his apartment within days. It just turned into madness immediately. And so we posted notices saying, hey, look, you can't do that, stop. You got 3 days to comply. Posted multiple notices, and there was no compliance. So within 2 weeks of this Cletus moving in, we were filing an eviction motion for non-compliance with the courts, and then our odyssey began, really, from that point. So the courts notify us, and they say, hey, look, you're going to work with Judge Hall. And I immediately flagged that as a problem with our attorney, because Judge Hall and I are former colleagues at the legislature, and I know him, and I have lunch with him on occasion. And so that would be a problem, and he would need to recuse. And so we notified our attorney of that, who talked to the clerk, and the clerk's like, oh, no, it's not a problem. We can make that work. We'll be fine. Well, of course, we get to the court date a couple weeks later, and what does Judge Hall do? He has to recuse. He sees me there, and he's like, Mr. Defendant, Mr. Tenant here, I know this guy. Are you okay with that? And of course, he's not okay with that. And so Judge Hall recused, which means we got delayed 2 weeks while we were rescheduled for another judge, Judge Renquist. We show up to Judge Renquist's court, and at this time the tenant is trying to bargain with us, saying, hey, look, if you just give me all my deposit back, I'll move out. But that's going to leave us with no money to pay for the eviction costs that we'd already incurred at that point. And we're like, no, you just need to leave, and then we'll get squared up. And he was trying to shake us down for the deposit. But we go into court, and we're sandwiched in between an emotional adoption hearing and a criminal trial. So we have this little hearing, and the judge realizes that there's going to need to be evidence presented, and it's going to take a minute to go through this hearing. And he's like, well, I don't have time for this right now. We're going to have to reschedule. So we rescheduled 2 more weeks out from that. And what happened then is there was a scheduling conflict or problem, and we were not notified of the proper hearing time. It got changed on us, and we weren't notified of the change, and so we missed that second hearing, which means we had to reschedule again. Keeping in mind at this point the tenant is there, and the charitable institution that we were working with knows he is being evicted for non-compliance and has stopped paying rent at this point. So things are getting hairy. Well, we get scheduled up with Judge Valencia-Ortega, and here we are 2 months into this deal, and she looks at the case and she's like, okay, look, yeah, this is pretty clean cut, we're going to hear this. And then the tenant says, well, Judge, I need an attorney. And she's exasperated. She's like, fine, you got 24 hours, go get an attorney and we'll meet back. And he's like, that's not enough time, I need more time. So she capitulated and basically said, okay, we'll give you a week and you get to hear the case with another judge. So we schedule out for a week, and we get scheduled with Judge Nieder. And Judge Nieder looks at this case, and she's looking at the history here, and she's like, well, golly, you've made the grand tour through the 2nd District Court of Utah, and we've seen everybody. So she anyway, it was a short hearing. She basically just told the tenant, look, things aren't right, you got to get out. And she signed the writ of restitution, and we were able to do a lockout a week later and get Cletus out of the apartment. Of course, when we show up to lock Cletus out, there's like 7 people in this little apartment. They're all high, spilling out into the front yard, and they all mount up on bicycles and caravan off to destination, unknown. So the property was left a total disaster. We had cleaned it up, made it tidy, and what we were left with was all of their furnishings. They had damaged the electrical. During his stay, he and his friends were playing around in the cellar and bumped into some plumbing and flooded the basement. We had 3 or 4 feet of water in the basement, or in the cellar, which totally destroyed the water heaters that were there. We had to replace and repair the water heaters, both of them. And so the deposit we got from this guy was 2 months of rent, but with the amount of time that passed where rent wasn't being paid, plus the attorney costs, plus clean out costs and all these things, it didn't cover the costs. And so this is where the owners are left holding the bag in this situation. So there's some takeaways from this story. One is that sometimes the courts are the law is fairly rigid. The judge makes determinations based on what the law says, and with evictions it's pretty clean cut. If you don't pay, you got to go. But sometimes courts and judges can use administrative rules to accommodate tenants a little bit, and that's usually through scheduling, through delays. Really the flexibility there is with time for the tenant, and so that can be and seem unfair to landlords, but that's just depending on the court or the judge. Sometimes that is something that has happened. During COVID, we had a judge. It was a very clean cut case. Tenant was down 4 months on rent. We heard the case and it was adjudicated in our favor, but the judge did not sign the writ of restitution for 40 days. And that was so bad, I had to contact my state representative and have him draft a bill to deal with the courts on that. Now, the courts hate it when the legislature plays in their sandbox, and so they got word of this happening, and they went in and investigated and found some things that where they, disciplined or corrected the judges for holding on to paperwork and not signing it quickly after a case is heard. So that was, the court self-corrected in that regard, and a bill didn't have to be run, but in the end. But anyway, this is something that happens, and if latitude can be granted, sometimes judges will take it because of personal preference or however they feel things are happening with that case. So, and again, I won't name names because the judge knows who they are. Also, this rapid rehousing program, so it's a HUD grants, federal money, and it comes into local administrations or local institutions that run the program. But it's basically, at least the way it's happening here, is it's just throwing money at a problem. So you have a homeless person, a person without housing, and the solution is, let's just pretty much at any cost put a roof over their head. And they may not be prepared for that space. I mean, as you can see in the before and after pictures, that this tenant was not prepared to be responsible for a rental apartment. They tore it apart, they abused it, they mistreated it in a very short period of time. Case management really needs to be involved with folks like this, where they're incrementally introduced or reintroduced back into society or whatnot. We know he was coming from the halfway house, but this is a question about what resources are available, what can society do to mitigate this, because it's the cost is being borne by the private sector, and so the private sector is going to say, no, we don't want to participate because this costs us more money than we get from participating. And so it's difficult questions, but what's happening right now does not appear to be working for those individuals that it serves, or for the landlords that are serving them. And so food for thought there. But that's a recent experience we had. Often in this business, no good deed goes unpunished. And yeah, we'll talk some more later. Thanks.